that for that to happen, it is going to require a constitutional moment of its own kind in the life of this institution, which I believe has been long overdue. The constitutional history with reference to this institution as a whole, and especially the Supreme Court, would show that its own roles have constantly evolved in the light of the socio-political context. In the 1970s and 80s, it was a decade where the Supreme Court expounded the basic structure doctrine. In the 80s, it constantly expanded the scope of Article 21. And by the 1990s, it became somewhat of a good governance court by innovatively interpreting constitutional provisions to address the inadequacies consequent upon executive and legislative inactivity. In the first 50 years since our independence, the Supreme Court has created a very sound jurisprudence, which we continue to reap from. It is the inertia, really, that has kept us going till now. But the way things stand today, court processes are a trial, even before the trial has begun. While I cannot say if it is a collective failure on our part, but for a nation governed by the rule of law, is it not a matter of concern that to this extent, at least, we are defying the idea of inclusiveness? Not a reform, but a revolution is what it needs to be able to meet the challenges on the ground and keep this institution serviceable for a common man and keep it relevant for the nation. For the effectiveness of the judgments to show, the justice dispensation system has to be made more result-oriented, namely to say, more focused on enforcement. I understand what Mr. Arun Suri, he is not present today, had suggested when he wonders if the judiciary is not being an accessory to the resulting deterioration, which in its hopefulness and optimism doesn't go after its mandate till its implementation. We give it up halfway. I find it difficult to agree with Mr. Suri and his proposition wholeheartedly. But I will certainly say that the judiciary must be more proactive and more on the front foot. This is what I would call as redefining its role as an institution in the matter of enforcement and the efficacy of the spirit of its dictates, of course, subject to constitutional morality. Here, separation of powers. I'll even go ahead to say that the institution at all levels needs to be more dynamic in a matter of interpretation of laws. And this is what I mean to say by a constitutional moment of its own kind. However, it is going to be a tall order, both at the micro level and the macro level, because both come with their unique sets of challenges. By micro level, what I mean is the administration of justice on a day-to-day basis. Here, the so-called inefficiency and slow processes in the judiciary have been historical challenges. I'll put it very simply. The judiciary today is not a poor workman who blames his tools. It is a workman with no tools. I am not going to keep you busy with the figures that we keep consuming every day on pendency, areas, judges' strength, etc. But in the light of what a French author had once said, I quote, "Everything has been said already, but as no one listens, we must begin again." I will only ask and request those at the helm to finally listen so that we must not have to begin again. In addition to that, I also feel that there is a pressing need to explore the endless limits of legal services mechanism. Legal awareness and legal empowerment